First, we have Janet, then Mel, and then myself speaking, and to finish, we have Jess M and Jess C.
The court system in Australia is made up of a hierarchical structure. It is a way of structuring courts into different areas of jurisdiction and responsibility. And it also allows for the process of appeals within the different levels of the court system. The courts are divided into Commonwealth and state courts. The Commonwealth courts consists of the tribunals, Federal Court, Federal Circuit Court, Family Court and the High Court. The state courts of Victoria include the Magistrate, County, Supreme, Children's and Coroners Courts, and also the Neighbourhood Justice Centres. You can appeal your case at each level until you reach the High Court of Australia. Once you've reached this court, their decision is binding and no more appeals can be lodged. The court system that we will be focusing on for this presentation is the Magistrates Court. The Magistrates Court is the first level of the Victorian court system. According to the Court Service of Victoria of 2019, there are 52 magistrate courts in Victoria and they handle approximately 90% of all the cases that make it to court. The Magistrates Court deals with matters relating to civil, criminal, industrial, family-related matters. Civil matters consist of a range of disputes and claims. It is recommended that all parties go through a mediation process to see if the matter can be dealt with outside of court first. According to the Law Handbook of 2019, most criminal cases are minor. The Magistrates Court has the jurisdiction to handle all less serious cases, which can include damaging property willfully, loitering, and being drunk and disorderly, though they still have jurisdiction to handle some indictable cases, which are more serious offences. With the more serious offences, the prosecutor and the defendant can ask to have the matter heard in a higher court, such as the county court with a judge and jury. To provide an individualised, service-focused approach that can also offer access to rehabilitation programs, the Magistrates Court has been divided into 6 specialist courts. These are the Koori Court, the Family Violence Division, Drug Court, the Industrial Division, the Assessment and Referral Court, and the Neighbourhood Justice Centre. The Broadmeadows Court, where our group visited, had the following specialist courts. These were the Koori Court, Criminal, Family Violence Division, Children's Court, Custody Matters, and Personal Violence and Stalking Matters. As our group visited the Family Violence Court, the rest of the presentation will focus on intervention orders. Another key area of the Magistrates Court is court etiquette. All courts are formal in their structure and atmosphere, though the Magistrates Court is less formal than the higher courts. The magistrate and lawyers are not required to wear a wig, jabot, or formal dress robes, though according to the Victorian Law Foundation, this formal attire is being used less in the higher courts. When attending the Magistrates Court, it is required that you wear neat, smart casual clothing and do not wear hats or sunglasses. Your appearance shows the magistrate how serious you are taking the matter. When entering and leaving the courtroom, it is expected that you bow your head, as this also shows a sign of respect. While waiting for your case, or if you are a spectator, you must not talk unless your case is being heard by the magistrate. If the magistrate speaks to you, you must stand and address him or her as Your Honour. Broadmeadows Magistrate Court, our group viewed several court proceedings in regards to family violence intervention orders. The definition of family violence, according to the Law Book of 2019, is any form of threatening, coercive, controlling, or dominating behaviour that makes a family member fear for their safety or their well-being, or for the well-being of another person. The Magistrates Court of Victoria website, 2019, they define family violence can include physical and sexual and economic abuse, property damage, emotional, social, or psychological violence threats, coercing, controlling, dominating, or terrorizing behaviour. A person who is experiencing family violence and feel that they need short or long-term protection from a family member, they can apply for an intervention order under the civil law. The process of applying for an intervention order would be to attend an interview with the registrar at the Magistrates Court. At the interview, where you will be required to talk about personal and intimate details and explain why you are making this application. The registrar will help the applicant fill out the application form and then give notification of a court date. They'll give the applicant all the copies of the documentation and also fax over to the police information so they can serve the respondent with the court summons. On the day of the court hearing, you must turn up at least half an hour before the time your hearing is being heard, and be prepared to be there for most of the day. Both the applicant and the respondent should be present for the hearing. The case will be called by the bench clerk over a loudspeaker. If you have legal representation, your lawyer will be present, or if the police have applied for the intervention order, the police prosecutor will be present. The magistrate will read over your application and may require further information as to why you are seeking an intervention order. If you have witnesses, they will be required to take an oath or affirmation before they provide testimony. If the respondent is present, they will be asked if they are agreeing to the order or contesting. They also have the chance to present information that is related to the case. After all the evidence is presented, the magistrate will make a final ruling on the order and grant or not grant the application. If the order is granted, the magistrate will define what family violence is to the respondent and also go through the conditions and timeframe of the order. If the respondent does not think they will be able to keep their distance or drive home a certain way that will break the conditions of the order, they can inform the magistrate and they can make amendments if needed. Before the applicant and the respondent leave the court, the registrar will type up the order and distribute the copies to the relevant parties. A copy will also be faxed over to the local police station so they have a copy on file if the order is broken. If the respondent breaks the conditions of the intervention order, the case then becomes a criminal case. There are key personnel present at a court hearing. The first is the magistrate. The magistrate is the main person that hears the case that is outlined before them, and they decide the final outcome. This could include delaying the court case to another day, whether the defendant is guilty or not guilty, and any relevant fines or penalties that may be incurred. In front of the magistrate, but below them, is the bench clerk. They sit in front and announce the cases over a loudspeaker or call certain people into the courtroom. He or she will administer the oath or affirmation to any witnesses or to the applicant and the respondent. They will also read out any charges within the case and they direct people where to stand. The registrar provides a number of services to the magistrate court. They provide information and procedural advice to people, but they are not allowed to give legal advice. They are to remain impartial, and they are responsible for giving the documentation to all the people involved within a court case. And they can even provide or perform a marriage service. They are celebrants as well. The police or public prosecutor will be in the courtroom, and they are mostly the senior police with legal training or a lawyer who is there on behalf of the applicant. The main duties is for them to provide evidence that backs up any charges. They can negotiate conditions with the magistrate and with the applicant, and they conduct the case in front of the magistrate. The defence lawyer represents the respondent. They advocate on behalf of the respondent. They will present information to the magistrate. If there is a not guilty plea, they will provide information that raises doubt in any of the cases. And they will also help negotiate terms and conditions of any orders that the magistrate enforces. The interpreter is a service that's offered by the court systems for people who have a non-English speaking background. They interpret in all different languages between all the relevant people in the courtroom. The final personnel that has a good role in the court system is the court network. They are a group of volunteers that provide information and support either over the phone or face-to-face, and they are there to support the applicants when they go into court. Mel will now talk about the observed legal matter and the relevant legislation that goes with intervention orders.
As already mentioned by Janet, the Family Violence Court is concerned with issuing intervention orders. Both civil and criminal legislation provide avenues for dealing with family violence, but civil law provides an effective, quick, and easily accessible way of gaining immediate short-term and long-term protection via family violence intervention orders. As well as the definitions of family violence provided by Janet, it also includes property damage and harm to animals, and in the case of children, child abuse. This includes a child witnessing or hearing violence or being exposed to the effects of family violence. There are two types of intervention orders. The first type of intervention order is the Family Violence Intervention Order. A family violence intervention order is legally enforceable and designed to protect the person, their children, and their property. It may include conditions that require the respondent to stop the behaviour, not have any contact or communication, including through an intermediary, with the protected person, or go near the protected person. A family member includes people who share an intimate relationship, whether it is of a sexual nature or not, parents and children, relatives, including by birth, marriage, or adoption, and anybody that is seen as being like family, such as a guardian. The second type of intervention order is the Personal Safety Intervention Order. These orders can help with disputes between non-family members, such as neighbours, friends, work colleagues, landlords, students, and strangers. Intervention orders have two levels, interim orders and final orders. An interim order is a short-term order that can be placed until a magistrate has had the opportunity to hear all the evidence and make a final decision. It carries the same power as a final order. A final order is made when a magistrate is satisfied that the respondent has committed family violence and is likely to do so again. Intervention orders are civil matters, but breaking the conditions included in an order make it a criminal matter that carries the possibility of a prison sentence, a fine, or other penalty, such as a good behaviour bond. Legislation relevant to the matter includes the Family Violence Protection Act 2008, the Personal Safety Intervention Orders Act 2010, the National Domestic Violence Order Scheme Act 2016, the Stalking Intervention Orders Act 2008, the Magistrates Court Act 1989 and the Crimes Act 1958. The purpose of the Family Violence Protection Act 2008 is to boost safety for children and adults who have experienced family violence, to lessen or avoid family violence as much as possible, and to hold perpetrators of family violence accountable for their actions. It aims to do this by providing a system of intervention orders and safety notices, and by making it a defence to breach such orders. The Personal Safety Intervention Orders Act 2010 functions to protect the safety of victims of family violence and to advocate and assist with dispute resolution through a mediation process where it is deemed appropriate. The Act aims to achieve this by again providing a system of personal safety intervention orders and by making it a defence to breach these orders, as well as by encouraging mediation to assist with dispute resolution. The National Domestic Violence Order Scheme Act 2016 provides for national recognition of family violence intervention orders, family violence safety notices, and other domestic violence orders. It aims to allow enforcement of domestic violence orders from all states and territories in Australia and New Zealand within the Victorian jurisdiction. The main purpose of the Stalking Intervention Orders Act 2008 is to provide a system of intervention orders in the cases of stalking. It lays down the definitions of stalking, which include following another person with the intent of causing physical or mental harm, or arousing fear or apprehension in a person for their own safety. It also covers publishing content about someone on the internet by email or electronic communication, keeping someone under surveillance and interfering with a person's property. The Magistrates Court Act 1989 is designed to establish the Magistrates Court of Victoria, to set out its jurisdiction, and to support the fair and efficient running of the Magistrates Court. The Magistrates Court Act also allows for putting an end to inefficient and unnecessary court processes and procedures, and for the Magistrates Court to be managed in a way that will ensure fairness, quick resolution of matters, and the best use of court resources. Finally, the Crimes Act 1958 lays down what constitutes a crime, punishments for those crimes, and how a defendant will be investigated and imprisoned. While matters brought before the Family Violence Division of the Magistrates Court are civil matters, unless the order has been breached, they are made generally because the person may have perpetrated one of the less serious crimes laid out in the Crimes Act. Key parties to the matter are the applicant, who is the person that initiates the application for a family violence intervention order and is known as the protected person once the order has been made, the respondent, who is the person against whom the order has been brought, and in certain circumstances, the police, who may apply for an intervention order on your behalf. Police are required to carry out a risk assessment where there has been family violence, and if the assessment shows that you, your family members, or your property require protection, they can take steps to ensure this, even if you do not agree. These steps can include applying for an application and summons, applying for a warrant, issuing a family violence safety notice, applying for an interim order, and applying for an intervention order. A warrant can be issued when police or the court registrar feel that the applicant, their family members or property are at immediate risk. This allows police to arrest the person using family violence. A family violence safety notice can be issued at any time to protect a family member, child or property. It can last up to 5 working days and carries the same power as an interim order. A family violence safety notice provides protection until an application can be made to a magistrate for a full protection order. And now Ainsley will discuss the legal matter and its associated legal and social issues in relation to due process and natural justice.
Natural justice, or procedural fairness as it is also referred to, is a common law principle that provides important procedural rights in administration decision-making. The 3 principles of natural justice concern procedural fairness and ensure a fair decision is reached by an objective decision-maker. Maintaining procedural fairness protects the rights of individuals and enhances public confidence in the process of family violence court. There are 3 components to natural justice, which are the fair hearing rule. This rule requires that a person must be allowed an adequate opportunity to present their case where certain interests and rights may be adversely affected by a decision maker. To ensure that these rights are respected, the deciding authority must give the opportunity to prepare and present evidence and to respond to arguments presented by the opposite side. The second rule is the rule against bias. This rule states that no one is to be judged. This is the requirement that the deciding judge must be unbiased when making a decision. The judge must act without bias in all procedures connected with making of a decision. A judge must be impartial and make a decision based on a balanced and considered assessment of the information and evidence. The third rule is the evidence rule. This rule is that a decision must be based upon logical proof or evidence material. Decision makers should not base their decisions on mere speculation or suspicion. Rather, a judge should be able to clearly point to the evidence on which the interference or determination is based. Along with the components are associated rights that everyone is entitled to. These are presumption of innocence, which is the recognition that the defendant is innocent until proven guilty, the right to remain silent, parties do not have to speak, and the right to fair hearing, trial by jury for certain indictable federal offences. And due process is a legal requirement that the state must respect all legal rights that are owed to a person. Due process balances the power of law and the land and protects the individual and persons from it. In regards to our visit to the Family Violence Court, it was very interesting to think about the concept of natural justice and due process and to see how it may or may not impact the decision-making process. Through observation, some matters came about in relation to legal and social issues. To set out the scene, the content and scope of the components of natural justice are not absolute. They are very flexible and can vary according to the nature of the IVO, the urgency of the situation, and the circumstances of the case. In regards to our visit to the court, all of the cases were centred around intervention orders, either individuals seeking, wanting an extension, or looking to make changes to a previous intervention order. In relation to the fair hearing rule, I found there were issues during the court matters. The first was concerning the respondents whose second language was English. The use of interpreters created a loss of communication between the respondent and the magistrate. The court hearings went quite quickly and the magistrate skimmed over the IVO in no detail. Some of the non-English respondents were quick to clarify things with the interpreter and then to the magistrate, although the magistrate interfered when the court user got rude and aggressive. This created questions and concerns surrounding the idea that the perpetrator did not fully understand the IVO and in future they may breach it. The magistrate also did not take into account if the respondent had actually done the things that were being put in the IVO. She made it clear that she did not want any admission of guilt or innocence from the respondent. The magistrate allowed the applicant to speak and tell their side of the story, but on the other hand, she did not allow the respondent to speak. She seemed uninterested in what they had to say. These issues implied that the fair hearing rule was not considered here in the court. Highlighting the issues raised surrounding the fair hearing rule emphasised that there may have been a bias within the magistrate. Most of the applicants came through were females seeking intervention orders against male perpetrators. The way the magistrate acted in the courtroom, not allowing the male perpetrator to speak and only hearing the female applicant's side and her reactions to what was being said, made it seem that she had a conflict of interest and pre-bias ideas. She did, however, show compassion towards a male prison guard who was seeking an intervention order. This raised questions around the idea that this was because he had a similar level of authority to her. One other issue that came about was how the courtroom worked like a machine. It was very clear the magistrate had a certain number of people to get through in a session. The magistrate went through the exact same procedure and said very similar things for each case. This is seen as an issue because family violence is a very complex issue and this was not represented in her approach. The social issues that arise in family court include gender issues. In our society, the Women's Research Policy and Advocacy Centre described family violence as the most prevalent form of violence against women. The social constructs of gender define roles for men and women as well as relationships between the two. The Australian Institute of Health and Welfare state that women are more likely to experience violence from a known person in their home. According to the Women's Research Policy and Advocacy Centre, statistics show that women are overpoweringly the victims and survivors of family violence and men are perpetrators. As discussed earlier, majority of the applicants were females seeking intervention orders against men. We saw in court a female magistrate, which can affect the procedure of natural justice due to society's ideas about gender. People involved with family violence court all appear to be from a lower socio-economic level and from a culturally diverse backgrounds. According to the Parliament of Australia, this specific group of people are a vulnerable group in our society and are at most risk of family violence. People from low socio-economic backgrounds and who are culturally diverse have a tendency to not have enough knowledge of services that are available to assist them in the decision-making process in courts. Discussed above was the language barrier with the magistrate, applicants, and respondents. This creates issues surrounding the procedure of natural justice as due procedure as important information can get lost in translation and people's rights cannot be recognised. Like we saw in court, the magistrate's reactions towards this group of people were seen as negative. She would get frustrated when respondents did not understand the intervention order and seemed like she had no time for them. Natural justice and due process should apply to everyday social work practice. Swain and Rice highlight the social work practice is centred around the application of power, and often those who are affected are not informed or are underprepared to challenge the legal system and the decisions made for or about them. The Australian Association of Social Workers Code of Ethics sets out certain expectations that relate to procedural fairness. Social workers must provide a competent and humane provision to service users. Keeping in mind of natural justice and involuntary clients, social workers are to advise all clients about the authority they hold in the decision-making process, as natural justice must always be applied to all cases. Rice and Swain go on to discuss that there is a need for social work advocacy when it comes to court systems. Decision-making that happens without the inclusion of service users or denies their voice goes against all of the principles of empowerment and self-determination to which the social work profession is centred around. It is important for social work advocacy in the legal processes, as they can let the service user know their boundaries, rights, and let them know of other supports that can be accessed.
Firstly, when discussing the availability of legal representation and supports, it is important to discuss what the court system has to offer to respondents, applicants, and affected family members. When considering all service users, volunteers, and employees, it is important to acknowledge the safety and security the Broadmeadows and other courts have to offer. That is, every person going through a security screening process when entering the court building that seizes prohibited items that might cause harm or injury to another person. Whilst it can be confronting, this ensures the safety for all people using the court system. Furthermore, the Broadmeadow Court also offers a safety room where victims of violence can wait in the court network until their hearing. This ensures that the perpetrator and victim do not have to sit in the same area where manipulation, physical and verbal violence could occur. It was witnessed that this room was frequently used and was certainly needed in most cases where the applicants visibly struggled to be in the same room as the respondent. After the respondent, applicant, or affected family member arrives to the court due to appointment or hearing, they let the court registrar know that they have arrived. A family violence practitioner or other support could be available to them, such as the list on the screen. As you can see, most of the supports are equally offered to applicants and respondents, other than the Victims of Crime Assistance Tribunal, also known as VOCAT, which is only offered to the applicant or affected family member. Furthermore, the respondent and applicant practitioners can provide information about the court and intervention order process, and can also refer to both parties to a range of support programs and support agencies. The Family Advocacy and Support Services is a new and enhanced service which combines specialist legal advice, risk screening, safety planning, social support, and referrals for people who are experienced, used, or are alleged to have used family violence. This service can be provided after the Information Referral Officer assesses the service user's eligibility for the particular support, or can also be referred to this support by the court registry, judge or registrar, family consultant, the court network, the Victoria Family Law Pathway Network, or by the Victoria Legal Aid or Community Legal Duty Lawyer. If the service user accesses this service, a duty lawyer will be made available to the service user to help with the legal problem and a social worker to help work through the issues. However, this service is only available in the Melbourne and Dandenong area. As a duty lawyer, their job is to help give printed information about specific offences and what happens in court, give you legal advice about the law and what happens in court, represent the service user on that day, and can arrange for legal aid lawyer to run service user's case. Duty lawyers are available in most magistrates' courts, however, it does not offer continuous support, as they can only provide the service users with assistance on a one-off basis. As it was observed that almost all or majority of the cases we had witnessed use a duty lawyer in their hearing, as duty lawyers are offered to people at court for a family violence matter or at risk of family violence. In saying that, the duty lawyer appeared to treat all service users equally and treated each case with autonomy. Social workers can help with the respondent and applicants with the relevant services such as accommodation, financial counselling, and drug and alcohol support services. Emergency housing can be offered to eligible respondents who have been served with the application for a family violence intervention order that excludes them from their home. And alternatively, 24-hour statewide housing assistance can be offered to the applicants who are homeless, at risk of homelessness, or escaping family violence. Furthermore, interpreters could be arranged to all parties with a family violence intervention order mattered if required. It was observed that on the day of the hearing, interpreters were readily available on hand and were called into the courtroom over a speaker when the respondent, applicant, or affected family member required one. The court network, known as the CN, is acknowledged to be one of the largest available services used within the court system. The Frontline Community Organisation is delivered by over 450 highly trained volunteers, which are referred to as the networkers. The networkers support people at courts and tribunals in Victoria and Queensland and have assisted more than 180,000 people who are required to come to court, including victims of crime, vulnerable witnesses, and family members of homicide victims of deceased persons. Their mission isn't to provide legal support, but to supply information and appropriate referrals to other services such as family violence services, victim support, housing, mental health, and community legal centres. The CN is an important component of the court system as they're acting in a similar social work role. They can assist people to be more aware of their own rights and feel empowered to speak for themselves. They are required to understand and respond to levels of vulnerability for individual court users, and they are there to empower and advocate court users who may feel vulnerable of disadvantages, may be attending court for the first time, are unfamiliar with court rules and processes, lack of knowledge of what is expected of them, feel frightened and unsafe, and may be representing themselves in a matter, or they may not feel confident with English as a language, or just simply need someone to listen to them. The only service that was available to the applicant and not the respondent was the Victims of Crime Assistance Tribunal. Applicants can apply for assistance from this service if they have incurred expenses due to a criminal act of family violence. Financial assistance may be awarded for reasonable expenses actually incurred or which are likely to be incurred in the future as a direct result of the crime. The tribunal can award an eligible applicant financial assistance for reasonable counselling expenses, reasonable medical expenses including dental, optometry, physiotherapy, hospital and ambulance expenses, the replacement of damaged clothing worn at the time of the crime, reasonable safety-related expenses, reasonable funeral expenses, lost earnings up to a maximum of $20,000, this is for primary and secondary victims only, special financial assistance for primary victims only, and distress and dependency related to victims only. Other legal and support services offered outside the court systems are legal aid, which are free to low-cost legal assistance to those in need, the local community legal centre, which is able to give legal information and advice, with some centres providing advice and representation at court, and most services being free. Women's Legal Service Victoria provides free confidential legal information, advice, representation and referral to women. Men's Referral Service, also known as No to Violence, which provides referrals and assistance to men who are victims of family violence. And the Desira Service, formerly known as the Aboriginal Family Violence Prevention and Legal Service, and this helps Aboriginal and Torres Strait Islander victims of family violence and sexual assault and works with family and communities affected by violence. When discussing the adequacy of legal representation and support supplied at court, it is acknowledged that whilst the services are equally provided to both applicants and respondents and strive to provide equal services, it is clear there will be some biases and conflicting of values when dealing with both parties, which may often lower the standard of representation and supports with the respondent, for example. It is also acknowledged that some of these services require some sort of eligibility process or filling out of paperwork, such as VOCAT. This may be polarizing to service users as they may well be eligible but do not want to go through more paperwork on top of the already long process of applying for intervention order. However, it must also be compared against how successful clients would be in the absence of these supports and representation. From the services offered in court, it is clear that they address a wide range of problems, from information on court processes to housing assistance, while also using different strategies and with a variety of desired outcomes. Therefore, the adequacy of the court support systems is sufficient, but could be improved. It was also observed that there were no social workers present. Although they were highly trained volunteers, social workers are committed to working with service users affected by family violence. The family court is where family violence is regularly exposed, yet the court system does not consistently appear to comprehend the complexities of the dynamics and coercive control, where perpetrators continue to control victims in many ways through the court processes. Social workers are trained in completing risk assessments and assessing victims and perpetrators through the legal processes of the Australian court system. The Australian Association of Social Workers understand that while family violence affects many members of society, it is a gendered crime that is mostly commonly perpetrated by men against women and children. Thus, social workers understand that some women are at greater risk of becoming more vulnerable to victims of family violence based on factors such as age, Indigenous identity, location, disability, ethnicity, English language abilities, which are all factors that may get looked over or totally missed when receiving other supports within the court system. Identifying family violence and understanding how to intervene is a complicated issue that requires significant understanding and awareness of its complexities by court staff. Highly qualified professionals, such as accredited social workers with informative knowledge and experience in understanding the complex and numerous factors that contribute to family violence, is needed.
In regards to the access that disadvantaged and vulnerable people have for the legal matters, it is heavily depicted on their socio-economic and their physical address. If you are from a wealthy background, the resources you have trump what the disadvantaged don't. People who are from a disadvantaged background are only able to access those resources that are free to them. They do not have the funds to be able to pay for legal advice. These resources are limited and in most instances are only allowed to take on a certain amount of cases at a time. Most of these services are funded by the government. A service that is available to those who are from disadvantaged backgrounds is Victorian Legal Aid. Victorian Legal Aid is a legal service that is set up to help those from low socio-economic backgrounds to be able to afford legal advice. There are multiple ways in which they can obtain legal advice. However, without phones and internet, it can be rather hard. You are able to call up the Victorian Legal Aid and receive free over-the-phone advice on current legal matters. However, this is all subject to which case you present. In some instances, they will not provide a service to certain cases. If you are in need of a lawyer, you can fill out a grants application form to see if you are applicable for funding to be able to pay for a lawyer. They also have 15 offices set up in the metropolitan and regional areas of Victoria. They have some in courts and tribunals. Their website is very easy to access and understand. They have also set up their website to accommodate for those who are from different backgrounds. We just simply change the language of the website, and then they are provided with the same information as those whose first language is English. The CEO of Victorian Legal Aid highlights in a report the multiple difficulties of those who are disadvantaged who living in broader communities. He talks about how family law matters are not always heard in the courts closest to where the parent resides. This means that parents often go through additional steps and delays to have their matter heard at an appropriate time and location. Without being able to access lawyers and services readily, they instead have to jump through unnecessary amount of hoops, adding on more time to those who are able to afford a lawyer. They both end up at the same place, just one takes a longer route. According to the ABC, Australians who face complex social and economical challenges encounter more serious issues that are typically aligned with government agency dealings, the health system, and consumer issues. Without the ability to afford legal advice, most of these issues are put aside. They are then asked to present their case to court without knowing anything about the legal system or law, and most often than not, they get treated unfairly and end up with a sentence that they really shouldn't have gotten. Does this mean that the people of the courts who are more educated and more knowledge-based are taking advantage of those who aren't? The ABC also points out in a 2017 newspaper article that in the last 20 years the government has been making cuts to the legal assistance sector. This means that legal services that offer free legal advice are becoming more and more scarce. Community legal centres are turning away 160,000 people per year due to not having the capacity to be able to take them on board. An additional 10,000 people a year are facing courts alone due to the cutbacks that have been made each year. This number is set to keep growing year by year. In 2017, more than 13% of the population in Australia lived below the poverty line. Yet legal aid has only been able to provide services to 8% of the population. According to the Law Council of Australia Justice Project, who provided the same statistics, was able to add that many impoverished people are considered to be too wealthy to receive basic legal help. In part 1 of the final report, People Who Experience Family Violence, written by the Law Council of Australia Justice Project, they highlight that there are 10 main reasons as to why people who experience family violence are unable to access justice due to barriers. These are financial barriers, homelessness, imprisonment and family violence, fragmentation and complexity, awareness, attitudes and education, fear and reluctance to report, cultural competency, understanding of family violence within the justice system, intersections and re-victimisation and system abuse. In the view of Australian lawyers from human rights, the expensive and adversarial nature of the legal system strongly favours men. It observed that women often lack financial resources to employ others to effectively fight on their behalf. This statement here highlights the gender discrimination that occurs and how if you are a woman you have a less likely chance of success as the legal system will strongly favour the male. The final report was stating that women won't leave their abusive partners or husbands as they are too reliant on their income and can't survive without it. And when they take it to the court, they cannot afford to pay for a lawyer on their own to help them, so they do not leave the abusive relationship. Other issues such as language barriers, cultural backgrounds, disability, sexuality, or geographical isolation can compound with financial disadvantage to make access to a legal service intimidating and difficult. In order to move into the family violence system, there is no single pathway into the system, and rather multiple entry points, and overlapping services at both state and the federal level. Some of these could be, but not limited to, are police, child protection services, courts, and schools. The Law Council has summarised issues that arise when people are self-representing themselves, such as the need to fill out complex forms, the need for a higher level of general English language. From what we saw at our court visits was that 90% were not from Australian backgrounds, and that almost all of them needed a translator, which shows that their level of English wasn't going to be high enough to be able to do it on their own. In order to self-represent, you need to be able to understand law terms used or legal language, to be able to follow what is happening and understand what is going on. Without a lawyer to help and no understanding, it is hard for self-represented people. So our human rights, everyone has access to these, and every one of these rights applies to everyone. However, does this really happen? Using the Universal Declaration of Human Rights, we are able to touch on just a few of those rights of the disadvantaged or the vulnerable that have been violated. Article number 7 states that all are equal before the law and are entitled without any discrimination to equal protection of the law. All are entitled to equal protection against any discrimination in violation of this declaration and against any incitement to such discrimination. People who are disadvantaged are having Article number 7 violated, as they are abused as they are not receiving equal protection of the law. There has been so many significant cuts to funding for those who need it the most through services like Victorian Legal Aid that they haven't had the right to protection of the law, and to some extent some are even going to court without any legal representation. Once again, amongst other things, Article 10 states that everyone is entitled in full equality to a fair and public hearing in an independent and impartial tribunal in the determination of his rights and obligations of any criminal charge against him. This refers to fair. It is not fair if you're going up against someone who can afford a lawyer and you don't have any legal representation or any understanding of what is going on. They are an unfair disadvantage and will be seen to win so easily without any competition. Article number 12, subsection 2 states that everyone has the right to equal access to public services in his country. Once again, back to the current cuts, so many hundreds and hundreds of people are being violated of their right to access to public services. They have taken so much money away from this sector that at some point in their time there will be no access to free legal advice. As social workers, we need to strongly advocate for these people who are having their rights violated. We can do this through using the codes of ethics, social workers' core values, 2 of which stand out: respect for persons and social justice. These people aren't being respected, and we as social workers need to advocate for them to have the same right as everyone else, and to be given the same opportunities through fair hearings, and to have a lawyer representing them, and to know about legal issues and matters.
It can be concluded that the family court involves an intricate process when applying for an intervention order, and it's associated with a range of relevant legislation and has a strict hearing process at court. It was further shown to have a wide range of personnel and court supports present, including a number of legal issues, as well as some concerns of meeting human rights effectively, which can ultimately impact on the broader social context. It is evident that the family courts act like a machine which works well but evidently needs improvement. That's the end of our presentation, and here are our references.